opening note, there's been a lot of talk about November 2012. November 2012 was the day that Lilly filed his notice of intent to commence an arbitration under NAFTA. November 7, 2012 was the day that Lilly filed its application for leave to appeal from the second Court of Appeal judgment dismissing or upholding the judgment below that had invalidated its olanzapine patent. And it's not coincidence. It's really not coincidence. Lilly, in its application for leave to appeal, which is like your certiorari applications to the Supreme Court of the United States, it filed an enormous amount of evidence, including affidavit evidence from Chief Justice Mitchell of the U.S. Federal Circuit and Lord Justice Robin Jacobs from the UK, who was one of the very most preeminent patent jurists in the UK. On the 4th, 5th, 6th of November of 2012, Lilly was feverishly walking around this city getting congressmen, senators, and trade representatives to sign letters that Lilly had written complaining about the Canadian patent system. The reason I tell you all that is this is all a construct. This was all designed by Lilly in order to try to convince the sage jurists in the Canadian Supreme Court that although it had lost on the olanzapine patent 6 or 8 times in the lower courts, when you follow the course of the litigation, it really should have had a valid patent, and the Supreme Court should overturn those lower court decisions and uphold its patent. And I was there from day one, from 2004 right through to 2013, when the Supreme Court of Canada finally said, no, Lilly, you've had it, it's over. You can't bug us anymore. I was there at every twist and every turn, and I can tell you that this Promise Doctrine is completely fictional. It's completely fictional, and I'm astonished, really, that we're all sitting here talking about something that Lilly has created. Now, I've talked to Richard Gold about this many times, and I've read all of Norman's things. I've spoken to him briefly. The concept of a promise in Canadian patent law is not new. It comes from President Thorson in a case called New Process Screw in 1931, where he was examining the utility of some double helix screws, and you can imagine how complicated those would be to even imagine. And he found that the promise of the patent that these double helix screws would work wasn't met because they didn't work. It's just another way of saying, what has the patentee said his or her invention will do? And of course, in order to understand and ascertain what the patentee has said his or her invention will do, you have to read the patent. And Lilly says reading patents is bad because everyone reads them subjectively and there's ambiguity and you're never sure how somebody else is going to read it. But I ask you, isn't that what judges do all the time? Not with just patents, with contracts, with all kinds of treaties, all kinds of documents. That's what we ask judges to do, to read them. And now there are strictures around how you read a patent. To put yourself in the position of the person of ordinary skill in the art, and you have to infuse yourself with all of the relevant knowledge, common general knowledge at the relevant time, and you have to put yourself in that position to read the patent. But once you're there, you're reading the patent. You read the claims. And in the olanzapine patent, there were compound claims. But it wasn't a compound patent. It was a selection patent. So you can't stop at the claims, and this was the argument we faced in the Court of Appeal. Well, look, it's just a compound claim. But the Court of Appeal wasn't fooled because this was the second patent on that compound. So you had to, as others have said, you had to do more in order to justify a second patent and an extension of the monopoly. And under UK and Canadian law, except that UK law has changed, conformed with the EU, you have to show a substantial, peculiar, and unexpected advantage for the compound that you've selected from the prior class. And that's what Lilly did, and it adumbrated this huge list of side effect benefits that olanzapine would have. It was wrapped up in that overall therefore statement we saw earlier this morning. Overall, therefore, the compound of the invention has marked superiority and a better side effects profile, I think, is almost exactly the language in the patent. But the evidence at trial was that it didn't. But more importantly, the evidence at the trial was, first of all, that Lilly didn't know that it did. Lilly made these statements, and when I deposed one of the inventors, he told me that prior to the filing, or at the time of the filing, he couldn't have told anyone with his hand on his heart that it had any of the advantages, any of the side effect benefits that Lilly asserted in the patent. And that's exact language that he used. With his hand on his heart, he couldn't tell me. And the basis of the data that Lilly had at the time of the filing, there was expert evidence at trial that the predictive value of that evidence was nil. So Lilly didn't know what the properties of this compound were, nor could it have predicted them. So if that's not a speculative claim, I don't know what it is. And the same is true in the atomoxetine trial. I won't go through it step by step, but the thing I want to really leave everyone with is that there is no promise doctrine. Utility in Canada is either demonstrated or soundly predicted. The sound prediction of utility is meant to address this problem. It's meant to give, particularly pharmaceutical patentees, a way of getting patent protection before they've actually shown that the thing that they have does what they think it will do. That's the whole point of it. It's patentee friendly. So you can file before you've done your clinical study, and that was recognized in the leading case on this subject, which isn't the first case on the subject. It's always said to be the seminal case. It's not. That's the AZT, or AZT, as you folks would say, case having to do with the second use for the anti-cancer drug, using it for treating AIDS. It was recognized by the Supreme Court of Canada that there had to be some leeway here, that the patentees, particularly in the pharmaceutical space, needed to be able to file their patents before they'd actually done the work, or this catch-22 that Lilly complains about in its notice of arbitration would be real. So having got the benefit of that, pharmaceutical patentees in particular, well, I don't know if it's true of all of them, but Lilly in particular, complains that it's being held to too high a standard because if it bases its statement of utility on a sound prediction, our court said, well, okay, in the case of a sound prediction, you don't know, you only predict that the thing will do what you say it will do. So as a consequence of that, and because we're giving you something that you wouldn't otherwise be entitled to because you haven't demonstrated that your invention works, we think it only appropriate that you tell the world the basis on which you make this prediction. So you disclose the factual basis, you disclose the line of reasoning in your patent. And if you don't do that, then your patent's not valid because you haven't met the quid pro quo. And remember, it's a patent bargain, right? The patentee gives the public something in exchange for the public agreeing that the patentee shall have a monopoly. So back to my earlier point, I'm astonished that we're all here talking about Lilly's NAFTA arbitration. Frankly, I fully expected it would wither and die. May 16th, 2013 was the day that the cert application in olanzapine was denied, and I thought that was going to be the end of it. I was quite surprised that Lilly didn't drop it. At that time, it was only dealing with atomoxetine. Instead, they seemed to gain energy and added in olanzapine and started the whole thing again. But as to the merits of that claim, substantively, it's wrong when it speaks about Canadian patent law. And given that it was my client's cases that underlay it, I was asked to engage trade law experts in Canada to look at it. And from a trade law perspective, and you heard about that this morning, I frankly am quite convinced it has no substantive merit there either. So it's nice that we're all here, we're all talking about this. And it may go through to a hearing, but the highest I would put that case is non-frivolous. That's the highest I would put it. That's a phrase that was used today. There's three main arguments: the expropriation, the national treatment, and the fair and equitable. Taking them in reverse order. There wasn't a single complaint in either atomoxetine or olanzapine that Lilly was denied any due process, any natural justice. There was not a single complaint. So how can they complain now? Well, they're complaining now because they lost. The national treatment is totally misapplied. Lilly's argument on national treatment is not that I as a foreigner should be treated as Canadian companies, but that I as a foreigner in your country should be treated the way I would want to be treated in the United States. And that's just not how it works. That's not what national treatment means, as I've been told, under NAFTA or under any trade agreement. And without going into the meats and bounds, because I'm not a trade lawyer, the expropriation argument is similarly weak, I'm told. So where does this lead us? Lilly has been arguing for a year and a bit now that there should be harmonization, and that, well, I argued it before the Supreme Court of Canada on the leave application, and it's arguing it in this NAFTA thing, that there should be harmonization. I'm not hearing any of the academics from Canada saying we should harmonize, and this is who we should harmonize with. I'm hearing them say that's an extraordinarily difficult thing to even conceive of, that the standards are different between the US and the EU. And I think Richard said it when it was breaking up, but there was a World Intellectual Property Organization attempt to standardize or harmonize patent laws, which was shelved like 8 years ago because it was proving intractable. So I don't know what to make of this other than Lilly wants the law to be the way that they would like it to be so that they would win. Because they don't come out of the box, and they have never come out of the box to tell us these are the standards that should apply. All they're saying is we don't like the standards in Canada and they should all be harmonized globally. Well, that's not helpful. If you're being tasked with harmonizing patent laws around the world, you want to know what standard you're supposed to apply, not what standard is no good. But beyond that, and I'm going to go back to what Bersu was saying earlier, it's well recognized that TRIPS provides for national substantive doctrine in patent law and elsewhere. And that's as it should be in my respectful submission, because there is such thing as sovereignty and national integrity. Countries have a right to run themselves within their own policy concerns and their own policy dictates. But I do pause to note that neither of the professors on this panel agreed with Lilly. Even Norman, who's going to be appearing for Lilly as an expert in the arbitration, didn't say that there should be harmonization, nor did he say with what jurisdiction should that harmonization be aligned. So, in a gentle response to John's comments, patents do reward innovation, but there's a bargain there. If you want protection for your invention, in my submission, you've got to give something in exchange for it. And I would urge you all, if you have the inclination, though I hope you don't because it's not all that exciting, to go and read the Stratera patent. It's the worst drafted patent I've ever seen. It's got about 6 pages of narrative, 4.5 of which are quotes from the DSM. Like, there's nothing there. They're not telling us anything in that patent. They're giving us publicly available information and getting a seal on it, and it's allowing them to exclude people from the market. It makes no sense. Anyway, I've probably been a little too one-sided, but I have a passion about this, and it's not over. It's still going on because this NAFTA thing is going on, and there will be further steps, although that's a very slow boat, that one. They've just, I think, a month ago, had their first procedural hearing here in Washington, and apparently there's going to be an order published soon to tell us that in 18 months they'll do their pleadings. So that's not going anywhere very quickly, and I suspect that that's to Lilly's advantage, because I suspect that this is all driven by Lilly's overarching desire to dictate national and international policy around patent law to its own benefit, and has nothing, in fact, to do with the substance of patent laws in Canada and the United States or anywhere. Thank you.
Okay, thank you. So I guess the